the work that he has done on oral so far, and in particular, render accounts for his decision sometime last week to discontinue a case involving Unibank. When the statement came from his office regarding the discontinuation of that case, significant public commentary has been generated. And in keeping with the policy of transparency and accountability that reigns supreme in this government, he is here to explain his actions as part of the withdrawal of efforts to engage the people of Ghana on the way that government runs. So without taking any more of your time, I would invite the Honorable Dominic Ayuni, Minister for Justice and Attorney General, to take the microphone. Thank you very much. Honorable Minister, the microphone is yours.
Good morning, ladies and gentlemen of the media. As the Honorable Minister for Government Communication has indicated, I am here to give you an update on the developments that occurred last week with respect to the nolle prosequi filed in the Dufour case, in the Republic versus Governor Dufour and 7 others, and then also to update you on the ongoing investigations and prosecutions that I have initiated. But before I go into the details, I would want to, first of all, apologize for the fact that we had advertised that I was going to update you on a major investigation that has taken place that adopted the rumble in the jungle. You will recall that when I announced the investigation of the Kobina Eduboahin case, I ended up by saying that if you thought that case was a trailer in Manila, then wait for the rumble in the jungle. And so the rumble in the jungle was supposed to be today, but unfortunately, after the press release from my office in the Dufour case, significant public commentary, some of it adverse, others very positive, came into play. And I decided that it is, as part of the accountability and transparency series, it is important for me to, provide details because certain misimpressions were created, which are not accurate when it comes to the decision that I have taken. So I want to provide details on that. And then I'll update you on what we are doing, myself, my deputy, and the team at the AG's department with respect to the prosecutions. So, ladies and gentlemen of the media, my fellow countrymen and women, I am here this morning to account to the sovereign people of Ghana, as has been my practice since assuming office as Attorney General. Today, I will do two things. Firstly, I will provide further details on my decision to enter a nolle prosequi in the case of the Republic versus Governor Dufour and 7 others. And secondly, give an update on the ongoing investigations and prosecutions that I have initiated upon assuming office as Attorney General. On Tuesday, 22nd July 2025, I took the decision to enter a nolle prosequi in the case of the Republic versus Governor Dufour and 7 others. This decision effectively brought to an end the criminal trial of Dr. Kobina Dufour, a former governor of the Bank of Ghana and former Minister for Finance. I took that decision after a prolonged period of negotiations with my team of state attorneys, including the Director of Public Prosecutions and the receiver of Unibank on the one side. The team on the other side was made up of Dr. Dufour, the shareholders, directors, and managers of Unibank, and the receiver. As part of my constitutional duty to account to you, my fellow countrymen, I wish to provide further details on my decision for two reasons. First, I have always maintained that as your Attorney General, I owe you a duty to act transparently. Second, I think it is important to dispel certain misimpressions that arose as a result of the rather terse press release that are issued following the filing of the nolle prosequi. My fellow countrymen and women, in March this year, the lawyers for the Unibank directors and shareholders approached me with a proposal of their clients' intention to settle their indebtedness to Unibank. In response, I convened a meeting on the 25th of March with them, representatives, and the receiver of Unibank, Mr. Ni Amano Dodu. At the meeting, it became obvious to both parties that a reconciliation of Unibank's account with the Bank of Ghana should be conducted. Therefore, I authorized the receiver to engage in the reconciliation exercise with them to determine the full scope of Unibank's exposure. I directed that the parties adopt a holistic approach that combined liabilities under both the criminal proceedings and the ongoing civil proceedings, because they were obviously interrelated, in order to reach a unified resolution that will bring closure to all related matters. The objective was to assess the feasibility of a comprehensive settlement. The charges in the criminal case against the accused persons involved a total amount, and this is very important, a total amount of 1.2 billion Ghana cedis, not 5.7, as is being bandied about from certain quarters whose names I would not want to mention. Whilst the civil case involved a total exposure of 5.7 billion Ghana cedis. Now, ladies and gentlemen of the media, if you conduct your research in the High Court, you realize that the receiver subsequently amended the writ of summons and the statement of claim and revised the civil liability down to 2.8 billion Ghana cedis. Okay? So that is on record. That's a public record, and whoever wants to contest this is at liberty to go to the High Court and then, do so. It is important to state for the avoidance of doubt that the total exposure in the criminal case is part of the total civil case exposure. In other words, the 1.2 billion is not in addition to or on top of the 5.7 billion, which was revised down to 2.8 billion. The charges in the criminal case against the accused persons involve a total liability. No, sorry, I think I'm repeating myself. Now, the 5.7 billion was made up of the following. That is from the initial, stage of the case. 2 billion being loans and advances which Unibank made to related and connected parties. 3.7 billion being payments made on behalf of or on the instructions of the accused persons. Included in A and B above, however, was an amount of 2.1 billion which was alleged to be fictitious loans, to have comprised fictitious loans and fictitious transactions booked by Unibank prior to the placement in official administration. During the reconciliation exercise, the accused persons objected to the inclusion of the 2.1 billion on the grounds that the amount did not involve any direct cash outflows which could be recovered. The accused persons also objected to the inclusion of placements of 0.3 billion, that is 300 million, made to Unisecurities. Now, Unisecurities is a Securities and Exchange Commission regulated, not a Bank of Ghana regulated, related company that had been placed in liquidation and for which a claim had been filed with the official liquidator. In other words, the money was to be recovered. The recovery of this amount is being pursued independently through insolvency proceedings with the official liquidator of that entity. In summary, the above matters led to the revision of the previously reported exposure of 5.7 billion down to 3.3 billion, which comprise the following. The exclusion of 2.1 billion in the alleged fictitious amounts booked to the account of the shareholder who did not involve cash outflows. In other words, monies didn't go out to anybody. These were just book entries that were designed to make the books of Unibank look good. That is how come that in the criminal case, the charge of falsification of accounts was brought against them. So they did not loot the money. They did not give the money to anybody. They just made entries that were meant to give Bank of Ghana, the central bank, the impression that the bank was doing well. Okay? Then the exclusion of 0.3 billion relating to Unibank's placement with a SEC-regulated, SEC-regulated related company currently in receivership, which is being pursued separately through the insolvency proceedings. After prolonged negotiations, the accused persons, by a letter dated 7th May 2025, made a proposal to settle the revised outstanding obligation of 3.3 billion Ghana cedis through a structured approach. The accused persons offered to pay 2 billion Ghana cedis in full and final settlement of the outstanding obligations through the following arrangements: 800 million worth of assets to be transferred directly to Unibank, which is in receivership, which will now make that available to the Bank of Ghana. And then their active cooperation and participation to assist the receiver to recover an additional 1.2 billion from the direct beneficiaries paid out on their instructions. Out of the above arrangements, the accused persons have provided landed properties valued at 824 million Ghana cedis to Unibank, that is, in receivership. Further, in other words, indirectly to the Bank of Ghana or the Republic of Ghana. Further, the accused persons will be responsible for any shortfall in the proceeds realized from the sale of the landed properties. A total of 0.5 billion has to date been recovered out of the 1.2 billion being pursued from the direct beneficiaries. Recovery of the remaining balance of 0.7 billion out of the 1.2 billion Ghana cedis and the realization of the landed properties provided are expected to be completed over a timeline of 18 months. Although the preference would have been for me and my team for the accused person to settle the proposed amount in cash, immediate settlement in cash was not, from my sense of what transpired at the negotiations, a realistic possibility or a realistic option. In assessing the proposal submitted by the lawyers for the accused persons, I took into account the following factors. The receiver of Unibank acknowledged that the fictitious amounts totaling 2.1 billion did not result from cash outflows, but related to accounting entries that overstated the asset base of the bank, which predated Unibank's placement in official administration. B, a claim for the placement of 0.3 billion with the SEC-regulated entity was filed by the receiver with the official liquidator in 2019, and its recovery is being pursued separately through the insolvency process. 3, both the criminal and civil cases have persisted over 6 years with no immediate resolution in sight. The complex nature of the legal proceedings has significantly delayed any meaningful recovery. Now, come to think of it, those who instituted the criminal proceedings did not foresee the possibility down the line of recovering assets and never engage in any asset recovery process. They did not trace, to find out what assets were in the hands of third parties, including those who were in court. So whilst the criminal prosecution was intended to serve as a punitive and deterrent measure, it is through the civil process that actual recovery of funds is effectively pursued. The accused person's proposal fell within the receiver's mandate to maximize recoveries for Unibank in order to settle the bank's creditors, mainly Government of Ghana and some institutions. There is also a genuine risk that prolonged litigation could ultimately lead to lower net recovery, especially when accounting for legal costs, procedural delays, the time value of money, and the potential dissipation or concealment of assets. By contrast, the current arrangement secures the timely resolution or recovery of over 800 million Ghana cedis in assets and establishes a structured pathway for recovering an additional 1.2 billion Ghana cedis with the active cooperation of the accused persons. On the other hand, should the matter have continued in court, it would likely have faced prolonged delays, including multiple procedural applications, adjournments, and appeals. Even if judgment were eventually obtained in either the civil or criminal proceedings, enforcement and execution could take years, further deferring any meaningful recovery. It is clear from the foregoing that I took a pragmatic, holistic approach by engaging the receiver and the accused persons to broker a resolution that settles both the criminal and civil dimensions of the case. This strategy recognizes that while criminal proceedings are punitive, the real economic value to the state lies in a non-conviction-based asset recovery approach. The terms of the settlement are structured to ensure that the Attorney General, the Bank of Ghana, the Minister of Finance exercise oversight over the recovery of the negotiated amounts. Progress under the agreement will be subject to quarterly reviews to ensure that the accused persons fulfill their obligations as agreed. Ladies and gentlemen of the media and my fellow countrymen and women, it is important to correct certain misunderstandings or distortions, deliberate in some cases, that our team picked from the media space regarding this matter. Since my press release, it has been said that by setting a minimum threshold of 60% for the recovery of assets as a condition for filing a nolle prosequi or terminating the banking sector cases, I have cut a deal which permits persons who have stolen or looted public funds to walk away with 40% of the loot. At least that is the narrative, by some sections of, the Ghanaian populace, particularly from our opponents in the MPP who were responsible for all this mess. Indeed, one writer on Facebook compared my decision to the situation where someone has stolen 6 goods and is being told by the prosecutor to return 4 goods and keep the 2. But my fellow countrymen and women, now this may seem like a joke, but it's a very serious expression of the sense of justice of our community. And it is something that I have used, to, get people who have come to me for plea deals to get them to think about the community's sense of justice. So, it is not lost on me, and I wasn't surprised when I read this on Facebook. But the goat thief analogy, intriguing though it may be, is an oversimplification of the matter. This is why. First, Dr. Kobina Dufour and the other persons standing trial were not charged with stealing or looting of public funds. They were charged with causing financial loss to the state, fraudulent breach of trust, falsification of accounts, as I have pointed out earlier, dishonestly receiving, and money laundering. But the facts and the evidence supporting these charges never allege that those standing trial personally benefited from the banking transactions that gave rise to these charges. Now, it's important to make clear that when someone is charged with, for instance, causing financial loss to the state, all right, it does not imply, from a criminal liability point of view, that they took the resources that have been lost. In other words, what we seek to do when we charge someone with causing financial loss to the state is to prove that they either intentionally or recklessly or negligently caused the state to lose resources or to lose funds. All right? Now, those of you who are old enough to remember the Quality Grain case, which and went all the way to the Supreme Court, involving the former Deputy Minister of Finance, Victor Salome, and a number of NDC officials in the Rawlings regime. You'll remember that in that case, Justice Afre was at pains to point out that though the accused persons had been convicted of the offense of causing financial loss to the state, they had not been convicted of stealing. They had not been convicted of personally benefiting from, the actions that were the subject matter of the criminal charges. All right? We must also understand that though the charge of fraudulent breach of trust is closely related to the charge of stealing, the facts and the evidence didn't show, okay, that in this particular case, they fraudulently breached their trust because they stood to benefit. Okay, they entered into transactions with third parties. Okay, which pointed to the fact that according to the case that was filed, they were trustees of depositors' funds. Now, which in itself is legally contestable, right? Because the banker-customer relationship is not one of trusteeship. It is one of contract. Now, that is legally, established in case law. There are case law precedents to the effect that that relationship is not one of trusteeship. So when someone deposits their money in a bank, all right, they are not keeping the money, they are not giving the money to the bank to be held in trust. Okay? So that if that were the case, then the beneficiary would be the one dictating how the monies, should be used. But banks are at liberty, because it's a contractual relation, a commercial relationship, at liberty to lend the monies, do, banking transactions with those funds in the way that they see fit, but in a prudential manner. Okay? So the basic point I'm trying to make is that these charges were themselves legally contestable. All right? Second, the analogy assumes that these charges, that is the goat thief analogy, assumes that these charges could be proven beyond reasonable doubt. On the contrary, the record shows that the charges were contestable, and there was a high likelihood that the defense could have raised sufficient doubt to procure an acquittal. And if that happened, as seen from the Beige Capital case, I would not have been able to recover even one cedi. Now, ladies and gentlemen of the media and my fellow countrymen and women, when I did the press release, I did not mention Beige Capital because at that point in time, I did not know that the decision was coming down. Now, as Providence would have it, the decision came a day after, right? I can now disclose that Beige Capital offered me or my office 10 million Ghana cedis. You can ask the lawyers for Beige Capital. Ask lawyer, Tadio Sori. They offered 10 million Ghana cedis in settlement. And I refused. Today, I can't get 50 pesos from Beige Capital. So the dynamics are complex. Those who are oversimplifying it and saying this is the goat, thief scenario, must understand that, it is more complex than just saying that the Attorney General says bring 4 goats and then keep 2. Third, by the time I assumed office and was approached by the lawyers for the accused persons, no asset tracing had been undertaken and no freezing orders had been obtained by my predecessors who filed the criminal charges. I could have been faced with a situation where the thief would have eaten 4 of the goats, thus leaving me with only one possibility, to recover only 2 goats. All right? In other words, assets depreciate and may even disappear before a diligent prosecutor can lay hands on them. Now, those of you who have followed developments in the, the tracing and recovery of the assets of General Sani Abacha, you remember him, the Nigerian military leader who died, I think, in 1998. Okay? You will realize that, he shipped a lot of the assets overseas, mostly to Switzerland and other parts of Europe and the United States. As we speak, okay, from 1998 till now, the recovery process is still ongoing. And even with the sophistication of the Swiss authorities and the US authorities in collaboration with, Nigerian authorities, recovery is still ongoing. So it is more complicated, than that. For people to think that it is just a question of the goats sitting there and for the Attorney General to say, bring all 6 goats back. But as I have crudely put it, if 4 of the goats have been used for light soup, how do you expect me, to retrieve the goats? Of course, jailing the person is also part of the process of accountability. And I do understand when Ghanaians say we should, jail them. But if we focus on the recovery, it will be very illusionary for anyone to think that the Attorney General or the Republic can recover 100% in every case. In some cases, I may be lucky, or let me say the state will be lucky if the assets are still there, they've not depreciated, they are there in full, and I can lay hands on them. That is how come that, if you have noticed since I came into office, we have always investigated the criminal conduct together with tracing the proceeds of crime. There has been no, except in the National Service case, there has been no a major announcement of investigation that has not included the assets of the criminal enterprise. And in the National Service case, I want to let you understand that. You remember that the Fourth Estate broke the story. Okay? The Fourth Estate broke the story in October. The people who were involved knew that ultimate accountability will be exacted. So they would have, as rational actors, do you expect that the luxury cars they bought, the houses they acquired, all the assets, the bank accounts would still be staying intact, waiting for the prosecutor to come and then lay hands on them? No. So we are doing asset tracing in that case. But it has been very difficult because they started the process of hiding their assets way back in October 2024. But yet, we are coming upon a number of them, and I will make those available at the right time. Lastly, in respect of the case at hand, 100% recovery was not possible, and a conviction was not guaranteed. In the circumstances, my team and I agreed to set a realistic threshold of 60% recovery. Sorry. We recovered 824 million worth of assets, which will be handed over to the state, and established a structured pathway for recovering the additional 1.2 billion Ghana cedis through the civil, process. And these are monies that are being held by third parties that owed Unibank, including, for instance, and I think that this is very important, contractors owed Unibank at the time that it was placed in administration 2.9 billion Ghana cedis. Unibank made overtures to the state to say, look, the Minister of Finance, pay the contractors and let the contractors, because they will be paid through our bank, we can take the 2.9 billion and we can satisfy, our books will, improve, and we can stay afloat as a bank. The then Minister of Finance flatly rejected that and and with the help of the Bank of Ghana, put Unibank into the situation in which we find ourselves. All right? Our current finance minister could have put NIB through the same process, right? But instead of using money to collapse a bank, the Honorable Atuforsin has used the money to revive it, for it to keep jobs and then continue to operate in the banking sector. That is what is called wisdom in governance. Having explained my decision to enter a nolle prosequi in the case of the Republic versus Withdrawal of Dufours and others, I wish to provide a brief update on the investigations and prosecutions that are currently underway. Trials have commenced in the case of the Republic versus Withdrawal of Dufours and 3 others, and that of the Republic versus Solomon Asamoah and another. That is the SkyTrain case. In the Withdrawal of Dufours case, we are calling only 3 prosecution witnesses. Our first witness has concluded his testimony. But for the third accused person's sudden withdrawal in open court of a lawyer's service, our first witness would have been discharged to give way to the second prosecution witness to start testifying. We expect our second witness to start testifying before the beginning of the legal vacation on July 31st, 2025. In the SkyTrain trial, we have concluded the case management conference. It is important to add that, but for the change of solicitors and the multiple medical excuses of the second accused person, that is Prof. Ameyaw Ekumfi, and recently of the lawyer for the first accused person, we would have called 2 of the 6 witnesses by now. That notwithstanding, the trial in the SkyTrain case is expected to start before the beginning of the legal vacation. The National Service Authority scandal case was due to be filed last week, as promised, when we stumbled upon evidence of malfeasance involving an account at the Bank of Ghana to which had been transferred an amount of 189 million Ghana cedis. Out of this amount, 80 million Ghana cedis cannot be traced. But we found 2 checks bearing the name and account details of the former Director General, Mr. Ose Asibe, which had been used to withdraw funds totaling a little under 2 million Ghana cedis from the said account. We have therefore halted the filing of charges so as to await the receipt of the evidence from the relevant state agencies, including the Bank of Ghana, Ministry of Finance, and the Controller and Accountant General's Department. In fact, as I speak, the Bank of Ghana signaled to me that this morning they are going to deliver the entire, bank statement, for my attention. I am, however, thank you. I am, however, happy to announce that at least 8 suspects in this investigation have approached my office for plea negotiations, including 3 former officers of the National Service Authority. Some officials have offered to testify against their colleagues, and some vendors and service providers are willing to come clean and testify as prosecution witnesses. When you build your docket well, this is the result that you get. 8, people are willing to testify. Persons, they are not coming to say hearsay. They are not coming to give hearsay evidence. People who were involved, okay? And we are, in negotiations with them and their lawyers, as a precondition, I tell them, you bring back the money that we have calculated that you took, you serve as a prosecution witness. That is the approach that we are using. Now, I'm sure the MPP will be very happy for me to insist that 100% be returned to the Attorney General before any deal can be, cut. Now, a report on the docket for the oral cases, including the mathematical sets, the All Africa Games, and the drip scandals are being prepared by the National Investigation Bureau for my attention. I expect to receive that investigative report in a few weeks for work to begin on filing charges in court. The Economic and Organized Crime Office has completed investigations in respect of Wontumi, Chairman Wontumi, and the former National Buffer Stock Company CEO, Mr. Abdul Wahab Hanan, and their accomplices. The results of both investigations will be announced very soon. The police CID have also completed a docket on the Akunta mining case and submitted same to my office. We have prepared charges and sent them back to the police CID for the suspects to be formally charged before their arraignment in court in the coming days. Ladies and gentlemen of the media, my fellow countrymen and women, in conclusion, I wish to remind you of the fact that when I announced the Kobina Edubohin investigation, I was blunt in stating the fact that I am open to engaging in plea bargaining with those who have been investigated and found to have looted or stolen state resources. I minced no words about my intentions and will therefore not shut the door to any accused person willing to enter into negotiations with my office for purposes of reaching a plea agreement. My approach is in consonance with the central plank of the oral, which is to recover the loot, which is to recover all the loot. But of course, you use all advisedly, because as I have pointed out clearly, it is not in all cases that it is possible to recover all the loot. So you recover some, realistically possible. Of course, recovering the loot and jailing looters are not mutually exclusive. And I believe that that is what citizens are pushing for. In other words, both can take place, and that will be full-fledged accountability. But anyone familiar with the plea negotiations would agree that it is rare to go into the negotiation room and come out without giving up something in order to clinch a deal. Our plea bargain statute captures that succinctly, as it contemplates that the Attorney General may even go to the extent of dropping charges in exchange for restitution. Also, under the Costs Act 1993, Act 459, an accused may plead guilty to a charge or charges and pay restitution where the offense involves harm to the property of the Republic, including financial resources. In that case, the accused is to be handed a non-custodial sentence, As the Attorney General, I will not oppose the use of Section 35 of the Courts Act to achieve the purposes of oral. Now, Section 35 is mandatory. Once the accused approaches the judge, okay, and pleads guilty to the charge, the judge is mandated, the judge could reject the restitution or reject the offer of the accused person. But once the judge accepts the offer of the accused person, I have no role in it, all right? Then the accused person must be given a non-custodial sentence. In other words, the accused person will walk home. So those who are saying that you are cutting a deal and letting criminals walk must understand that, okay, even the legislative framework existing at the time that I was in law school, I was in final year in Legon when this act was enacted, okay, contemplates that in some cases, the accused can pay restitution and get a non-custodial sentence. So if any accused person offers to come under Section 35, please, ladies and gentlemen, that is what Parliament has enacted. The Parliament of the first Parliament of the Fourth Republic do not expect that I will be able to say, do not impose. If once the judge accepts it, okay, I can make my representation to the judge as to why this is not a fit and proper case for restitution and a non-custodial sentence. Okay, but that can be rejected because the statute imposes, right, the power and authority to determine the circumstances under which that will happen in the judge, not in the Attorney General. The Plea Bargain Act, on the other hand, okay, imposes the power and authority to, negotiate the deal in the Attorney General. However, the judge has a role to play. The plea agreement must be endorsed by the judge before, it is accepted. Finally, make no mistake, ladies and gentlemen, about my intentions. I want to jail persons who have looted state resources, but at the same time, I am pragmatic enough to know that it is not in every instance that that is possible. In those circumstances, I will opt for non-conviction-based asset recovery. I thank you very much.
Thanks for watching. Please like, subscribe,
and click on the bell for more updates.